So what is the Fourth Amendment? The Fourth Amendment protects people from the government from unfair searches and seizures. The police cannot search your body, your house, or your car unless they have probable cause. Most of the time, they would need a warrant. So how do you get a warrant? The police have to explain why they want one. They must show that they have probable cause and they have a strong reason to believe that a crime or evidence has happened in a certain place. Then, a judge has to sign a paper showing exactly what will be searched. Once the warrant is notarized, the police can carry out the action, but they can only do what is written on the warrant. So now that you know what the Fourth Amendment is, let's go through an example of where the Fourth Amendment will be used.
You're under arrest for not coming to court.
Now, there are a few things that can happen in this situation. A police officer has to have a warrant in order to enter your house. If they do not, then you do not have to let them in. However, if they do, then you must let them in. So let's say Officer Kavya doesn't have a warrant. This is what may happen. You don't have a warrant. No, you can't.
I don't care. You're under arrest.
Oh, shoot.
So what you have in here? What? Drugs? You're coming with me.
No! I can't go to prison.
What you just saw there would have been protected by the Fourth Amendment. Officer Kavya did not have a warrant, but he just searched the house anyway. He did find illegal substances, but they would not be able to use this evidence in court. However, there are some exceptions to the Fourth Amendment, and I'll go over 3. One is if you give consent to your house being searched. If you do, the police can search your house. And if they find anything illegal in the house, it can and will be used against you.
Hey, I need to search the house. I heard some suspicious things about you.
Really, officer?
Yeah.
I guess so.
All right.
Another exception is hot pursuit. If you are actively running away from the police and enter your household, they can go inside and search the house. One last exception would be searching your car. Now, a vehicle can move, right? And you can hide evidence in your vehicle, and you have much less privacy than your home. So, police officers are allowed to search your vehicle with probable cause, and they do not need a warrant. Now you will witness a wonderful example.
Whoa. I'm gonna have to stop you right there. I smell something fishy in the car.
Really?
Yeah.
Really, officer?
Yeah, let me check.
I guess so.
Hi, my part was Mapp versus Ohio, and here are some background facts. Jory Mapp, the person that was involved in this case, was a resident of Cleveland, Ohio, and living in a private home. The Cleveland police received a tip that a fugitive involved in illegal betting activities might be hiding in Mapp's house, which was illegal at the time. And on May 23rd, 1957, several officers came to Mapp's home and asked to search the house. She refused to let them in without a warrant and standing up for her constitutional rights, Fourth Amendment specifically. And the police left but returned later with more officers, and they claimed to have a warrant but never showed a real one. It was just a blank piece of paper, and they waved it in her face. And Mapp demanded to see it. Again, they waved it in her face, and they forced the way into their home.
Mapp chilling at home, minding her biz. Cops came, knocking like, open up, miss. No warrant in sight, blank paper, just broke right in. Found some stuff, said, that's a sin. Fourth Amendment, yeah, that's the rule. No search or seizure, unless it's cool. But they had no paper, no judge, no sign. So that search was way out of line. She took it to court, went up real high. SCOTUS looked and said, that's why. Continue, we tossed in this case. Throw out the fine. No warrant, evidence gets left behind. Impact, now states gotta follow the same exclusion. No fake searches, no confusion. Mapp changed the game, gave rights some muscle. Don't mess with the Fourth, cause we know the hustle. So in summary, cops busted in with a blank piece of paper. No real warrant, SCOTUS said, see you later. Now the exclusionary rule applies to every state. Mapp versus Ohio made sure illegal evidence holds no weight.
Mr. You're being charged with trafficking fentanyl resulting in death. That carries the death penalty under federal law. We have a witness saying you gave the pills to the victim and he was dead an hour later.
Hold on. Those are capital crimes. Did you speak to a grand jury before this, or did you know me here based on vibes?
Well, no jury yet. We have some solid leads.
Then you don't have a case. Serious charges like this, the Constitution says you need a grand jury to indict me before you can even put me on trial. Under the Fifth Amendment, you can't just be dragged into court for major crime unless a grand jury says there's enough evidence. No shortcuts.
Double jeopardy. No double dipping in court.
Mr. Joseph, the court is reopening your case for the alleged 2024 store robbery.
Wait, what? I was already found not guilty for that. You're trying to charge me again?
We think new evidence might show something different.
Too bad. I already went through trial. That's double jeopardy. Your Honor, you're violating my Fifth Amendment right.
The government doesn't get a do-over if they lose. If you're found not guilty, they can't charge you for the exact same crime again, no matter how much they want to.
Self-incrimination. You can stay silent.
Taylor, we know you are at the scene. You can make this easier if you just tell us what happened. Sorry, folks. Back to our scheduled programming.
With all due respect, officer, I'm not answering anything without a lawyer, and I'm invoking my Fifth Amendment right. You don't have to testify or speak in any way that could lead to you getting charged. That's your protection against self-incrimination, and if cops don't tell you that after arresting you... Miranda warnings, when they do and don't apply.
Actually, Taylor, let me fix that. You're officially under arrest. You have the right to remain silent. Anything you say can and will be used against you in a court of law.
But there are some big-time exceptions to those Miranda rules. Check this out.
The Miranda exceptions, sneaky situations. There's a loaded gun somewhere in this park. Where is it? Kids are nearby.
It's in the trash can by the fountain.
That's called the public safety exception. In emergencies, officers can ask critical questions without reading your rights first.
Name, address, birthday?
Taylor Jackson, 287 Sunset Boulevard, November 10, 1999.
These are routine booking questions. They don't count as interrogation, so Miranda doesn't apply.
Okay, fine. I panicked. I forged the documents.
If no one asked you anything, a voluntary statement can still be used in court, even if Miranda wasn't read.
Due process. Fairness matters. Mr. Joey, your public housing assistance is being terminated. There was a suspicious charge on your application.
What? I didn't get a warning, no hearing, no appeal. You're just cutting me off?
That's the policy.
Well, then your policy is not constitutional. The Fifth Amendment says I get due process before you can take anything from me.
You can't lose liberty, property, or benefits without a fair chance to be heard. That's due process, basic fairness.
Taking clause. Eminent domain is real.
Officer, chill.
Miss Taylor, we're building a light rail station. Your shop's in the way. The city's claiming this land under eminent domain.
Wait, so y'all are just taking my bakery? Where's my compensation? I've been here for 12 years.
You'll get market value. We'll negotiate.
The government can take private land for public use, but under the Fifth Amendment, they must pay you fairly for it. That's the takings clause.
Final scene. So let me get this straight. I can't be retried. I can stay silent. I get fair treatment, and I better get paid if the government takes my stuff?
Yep, that's the power of the Fifth Amendment.
We plead the Fifth.
Hello everyone, I'm here to present to you the case Miranda versus Arizona. In 1963, Ernesto Miranda was accused of kidnapping and rape. After being interrogated for 2 hours, he finally confessed. He signed a written statement of his confession, and it was the only evidence used at trial. He was not told he had the right to remain silent and get the help of a lawyer.
Which amendment protects these rights?
The Fifth Amendment. When Miranda appealed to the U.S. Supreme Court claiming the violation of his Fifth Amendment rights against self-incrimination, they accepted his case for appeal. The court ruled Miranda's Fifth Amendment rights had been violated. His original conviction was reversed, and he was retried. This time, the prosecution was not allowed to use his confession as evidence at trial. However, Miranda was convicted of the same charges and sent back to prison. In 1972, Miranda was paroled and he died in 1976 during a bar fight. The man who killed him was read his Miranda rights upon arrest. This case has led to the Miranda warning becoming a required part of when you're arrested in order to protect the constitutional rights of citizens. Next up, you're going to see an example of the Miranda warning.
You are under arrest. You have the right to remain silent. Anything you say can and will be used against you in the court of law.
You also have the right to an attorney. If you cannot afford one, one will be provided for you. So were you at the location where the crime took place?
Yes, I was there.
So you might be wondering, can this evidence be used by the prosecution in a trial? The answer is no, because it was already the next day and she was not Mirandized again. The public defender system is a government-funded service that gives legal representation for free to people who are charged with crimes and cannot afford a private lawyer. In terms of how well it works, it can be viewed as controversial with opinions that support and disagree with it. For positives, you get experienced public defenders who represent you, even if you can't afford it. So it ensures rights to people and lets them be protected under the Constitution. However, public defenders often have a lot of cases at once, which makes it really hard to give attention to each client and also sit down and speak with the client about the case.
Plug, I need my stuff. Thank you.
What's that?
That's nothing. It's nothing.
Are those drugs?
No, it's not. Oh my god, bro, I'm gonna go to jail. They said I have drugs. It was just Pokemon cards, bro. What am I gonna do?
Chill, Marco. You have rights. I'm your public defender. You're not going to jail yet.
Wait, I get a lawyer for free? What else do I get?
Well, you get nothing else physical, but you do have a right to a speedy and public trial, an impartial jury, being informed of your charges, a cross-examined witness, a subpoena witness, and an attorney, which is me.
Wow, that's amazing.
Now let's talk about the right to counsel. That means once you're charged with the crime, you get a lawyer. If you can't afford one, the court gives you a public defender like Jubchi here.
When should I next time to meet you?
Unfortunately, I am a public defender, and I defend people for free. I work with the government, and I know what I'm doing, but I got like 37 other cases, so we don't really have enough time to meet, but I'll try my best.
So you're basically a sleep-deprived and overworked superhero?
Yeah.
We learned even if you're accused of a crime, you still have rights, and public defenders are here to protect them, even if they run on caffeine and chaos.
Clarence Earl Gideon was 51 years old when he was arrested with felony theft. On the day of his trial, August 4th, 1961, he said he would like to appoint his Sixth Amendment right and request an attorney, but he was refused. Now he had to defend himself and was found guilty by the jury. He knew this was unfair, so he wrote an appeal to the U.S. Supreme Court. The court thought there was an injustice in the case and decided to take it. Gideon was appointed to an attorney, and the Supreme Court agreed with him about the fact that his Sixth Amendment, which states that all criminal defendants have a right to an attorney, was violated. He was found not guilty in his second trial. The court ruled that the states must provide free legal counsel to defendants who cannot afford a lawyer or indigents in criminal cases.